Good afternoon, ladies and gentlemen. Suzanne Dibble here, data protection law expert, coming to you raw and uncut. And I'm enjoying the discussion about data processors and transfer outside of the EEA and the issue over US data controllers, US processors, etc. And I did a video a few days ago about whether you needed a processor agreement and the standard contractual clauses. And I also talked about what happens if you're a US data controller using a US data processor. And I just wanted to revisit that and update you on a conversation that I had with the ICO today after holding for, this was a record actually, I think this was 1 hour 15 today. But this time they didn't cut me off, which they did. I was waiting for 45 minutes the other week and then they cut me off and I had to wait another 50 minutes to speak to somebody. I do feel very sorry for their support desk, their helpline staff at the moment. It must be a complete nightmare. So the first thing that I want to say that I didn't cover on the other video but is fundamental is that if you have a data subject in the EEA who is signing up for your lead magnet or in some way giving you their personal data, that is not an international transfer of data in itself. Okay, when we're talking about international data transfers and making sure that there are appropriate safeguards in place for those data transfers, we're talking about transfers from organisation to organisation. So whether that be a data controller within the EU that's transferring that data outside of the EEA, or whether that is a US data controller and a US data processor, the transfer, if you like, of the data from the data subject to the data controller is not an international data transfer where you need the appropriate safeguards. Okay, so that's the first point that I want to make clear. It's not actually completely obvious from the regulations, but I think if you anyway, I also just confirmed my thoughts with the ICO today, and they said yes, that's not what is meant to be covered by that. It's only organisation to organisation transfers. If they are international, i.e. outside from within the EEA to outside of the EEA, that's an international data transfer, and that's when we need to be concerned about things like, is there an adequacy decision, which means that the EU has judged that the country that the data is being transferred to has a sufficient data protection legislation in its own right and doesn't need further safeguards. So Canada is an example of that insofar as you're sending it to corporate entities. New Zealand is another example. But the US hasn't had an adequacy decision. So what the US does have is the Privacy Shield, which replaced the Safe Harbour. But as a number of people have commented on this group, the Privacy Shield is currently under review as well, and it is looking a little bit on shaky ground. So, and what the Privacy Shield is, it's basically a self-certifying way that companies within the US can say, we take data protection really seriously, and here's what we do, and it's enforced by the FCA, etc. But actually, there's in terms of the size of the US and the number of companies that I imagine there are in the US, only 4,400, I think approximately, 4,400 companies have signed up to the Privacy Shield. So it is, the big ones, yes, I think the majority of people have signed up to it, but even people like Infusionsoft, who I use as my email service provider and my CRM system, they are not signed up to the Privacy Shield. So it's, and we do have this, if you haven't found it already, there is a list of, well, it's not a list, it's a spreadsheet that people within the group have put together as to what status certain companies around, well, a lot in the US, but around the world, the sort of big software that online businesses typically use, where they're up to in terms of whether they are part of the Privacy Shield or whether they have made any statement about being GDPR compliant, whether they've got the standard contractual clauses in place, etc. So if you're wondering about your processes that you use, hopefully you've done the data inventory in my pack, you know who you're transferring all of your data to, you've worked out which country they're in, and then you've looked at the final column in the data inventory that says, okay, well, what is the relevant safeguard? And I say the first thing to check, adequacy of the country. If that doesn't apply, then if they're in the States, they're part of the Privacy Shield. If they're not, and Privacy Shield is really we'll call that an adequacy in itself, so that's an adequacy decision. And if there isn't an adequacy decision, then you're looking really at putting what are called standard contractual clauses, or sometimes are called model clauses. They're the same thing, it's just used interchangeably. Then you're really into putting those into place, which is fine if you are an EU data controller who is transferring data outside of the EEA. They work fine in that instance, and the SCCs for data controller to data processor are in my pack. There are also SCCs for data controller to data controller, and they're not in my pack at the moment, although I could add them in if anyone particularly needs them. But if for any reason, so that's if you're within the EU and you're transferring it outside of the EEA, then the SCCs, the standard contractual clauses, are generally a good solution, which will mean that you won't have to go and rely on a derogation, which could be, for example, getting explicit consent from every data subject. Okay, so SCCs, oh, the light's just gone a bit funny there in the background. Something always happens on these videos, doesn't it? Either the phone falls off, or the tripod's wonky, or gets some strange lighting. It makes it a little bit more interesting, doesn't it, really? So, if for some reason you can't enter into the SCCs, then you are looking at the derogations, okay? Because there are, in the GDPR, there are other mechanisms, other safeguards you can put into place, in theory, for the international transfer, but they're just not in place yet. So, for example, an approved code of conduct. We haven't got one of those yet. There's none of those yet. An approved certification mechanism. Haven't got those yet. So really, and then binding corporate rules, if people have heard about binding corporate rules, they're really for the international organisations, the multinationals. They take 18 months to get approved with the supervisory authority, costs a fortune in legal fees and back and forth and whatever. So BCRs are really only relevant if you are a multinational or of that type of scale. So really we're left with the SCCs and these derogations. So the derogations are Article 49, if anyone happens to want to go and read them. The first one is that the data subject has explicitly consented after having been informed of the possible risks of such transfers due to the absence of an adequacy decision and appropriate safeguards. Okay, so that does mean that on that derogation you would have to get explicit consent, and that would, for me, that explicit consent would need to be a tick box or something that's similarly obvious as that, so that you know that that the data subject has really understood the risks and is still happy to proceed regardless of that. Now, the next derogation I haven't really talked about before, and that is that the transfer is necessary for the performance of a contract between the data subject and the controller, or the implementation of pre-contractual measures taken at the data subject's request. So if you are a data controller based in the States, for example, and the issue is that the SCCs won't apply if you're a data controller based in the States, because they are written as though you are based in the EU, okay, is the problem. So and I covered this in the video the other day, if you are a data controller in the States and you're transferring data to a US data processor, and that data processor is not part of the Privacy Shield, then the next thing to look at would, in theory, be the standard contractual clauses, but they won't apply because they're written as though the data controller is in the EU. And I spoke to the ICO about this today, and they said, we looked at. I said, well, could we use the SCCs but just amend the clauses slightly to reflect the fact that it's a controller within the US rather than in the EU? And she obviously Googled something and came back and said, well, there was this specific thing that says that the standard contractual clauses can't be altered in any way. They can be lifted into another agreement, but the actual clauses can't be altered in any way. So in her view, at the ICO, she thought that you would not be able to alter the SCCs so that a US data controller could use them. Okay, so if you are in that position, you're a US data controller using a US data processor who's not part of the Privacy Shield, then according to the ICO, the standard contractual clauses will not do the job. So then you're left looking at the derogations. Okay, the first one, explicit consent, we've just talked about that. The second one is that the transfer is necessary for the performance of a contract between the data subject and the controller, or the implementation of pre-contractual measures taken at the data subject's request. So that might be where they're requesting a quote or something like that. Now, I gave the ICO an example here. So say you've got a US data controller who is a weight loss coach. They've got a lead magnet that says sign up here for your 10 steps to whatever, a leaner waist. I'm not very good at marketing, am I? Your 10 steps to a leaner waist. I haven't really got the marketing speak there. But so a EU data subject signs up for the free report on the US data controller's website, and that US data controller uses somebody like Infusionsoft in order to store that person's name and email address, uses it as a CRM, send them emails, etc. So a processor within the States. Now, Infusionsoft at the moment is not part of the Privacy Shield, and that weight loss coach could not put in place standard contractual clauses with Infusionsoft because, as I say, it anticipates that it's an EU data controller. So this derogation about being necessary for the performance of a contract, if you have contracts with people, so you've got customers who have signed up for a product or something like that, and you're storing their details on Infusionsoft, then and that is necessary for the performance of the contract. So, is it necessary that, maybe they've brought an 8-week program to a leaner waist? Still not getting anywhere with the jazzy marketing speak, but they brought their 6-week program, and you are facilitating that through Infusionsoft. So you set up a sequence in Infusionsoft, you're sending them the materials through Infusionsoft, etc. Well, that is, I think, necessary for the performance of a contract between the data subject and the controller. So for that, I think you could certainly argue that derogation would apply and you wouldn't need explicit consent. Now, my questions are over what's necessary. Does necessary mean that if actually there's another processor that can do that job, but who is, for example, part of the Privacy Shield or is based in the EU, or where there is not an international transfer of data, does that mean that it's not necessary? Because is it? I don't know the answer to that, but I'd make a good argument that it was necessary to use Infusionsoft for the performance of the contract between the data subject and the controller. Okay, I don't think it's not necessarily clear cut, but there's an argument there. But of course, that's only in relation to where there is a contract. So if you've got just people who've signed up for your free lead magnet, is there a contract there? Oh, again, it's certainly, in terms of for a contract to be formed under English law anyway, there has to be an offer, there has to be acceptance, there has to be consideration, and there has to be intention to create legal relations. So, is there an offer? Well, I suppose the offer is, would you like my lead magnet? The acceptance is yes, please, and they pop their email address in. What's the consideration? The consideration, arguably, is the use of their email address. I don't know. I don't know if that's what this means, but there's a question mark over it. And the ICO didn't know either. So what are we supposed to do? The other derogations are the transfer is necessary for the conclusion or performance of a contract concluded in the interest of the data subject between the controller and another person, okay, but it's in the interest of the data subject. the transfer is necessary for important reasons of public interest. I mean, what on earth does that mean? The transfer is necessary for the establishment, exercise or defence of legal claims. So, you know, I mean, again, there, could you argue that transferring it to a processor in the US, you know, maybe you're storing documents on Dropbox, say, and I think Dropbox is actually Privacy Shield, but say Dropbox wasn't part of the Privacy Shield, and you're storing important documents on that processor's servers in the States, you know, because you want to keep it there in case one day there is a legal claim. Is that sufficient for that? I don't know. I just don't know. The next one is the transfer is necessary in order to protect the vital interests of the data subjects or of other persons where the data subject is physically or legally incapable of giving consent. And the final one is the transfer is made from a register which, according to union or member state law, is intended to provide information to the public and which is open to consultation either by the public in general or by any person who can demonstrate a legitimate interest. Blah blah blah. So, you know, I mean, it's complex, isn't it? And I think that you know, if you want to be, you know, if you are, I think if you're a data controller in the EU, it's fairly straightforward. If you're transferring outside of the EEA and there's no adequacy finding, not in the Privacy Shield, then you put the standard contractual clauses into place. And there shouldn't really be a reason why you can't do that. US, if you're a US controller and you are transferring to a US processor, then I think that I mean, look, we've got to take commercial judgments here, haven't we? You know, there's like a week and a half to go until GDPR, something like that, until GDPR comes into force. And you're not going to, your processor is not going to be able to become Privacy Shield certified within that time. Neither are you going to want to transfer those operations to a processor who is Privacy Shield compliant. So that's your risk. And you're probably not going to want to obviously go and get explicit consent from every person on your database. So it's a commercial risk appraisal, isn't it? And if I were in that position of a US data controller using a US data processor that is not Privacy Shield compliant, then I would be speaking to that processor and I would be saying, what are your plans for becoming part of the Privacy Shield? And if they said we haven't got any, then I would be looking for other suppliers and doing a phased transition as soon as I could to limit my risks in that behalf. Because this isn't going to go away, and although there are certainly question marks over whether the Privacy Shield is the right mechanics for that safe transfer of data, and if that goes away, it's going to be something very similar with a few more bolt-ons. So it's not going to be a wasted exercise in trying to work with processors who are part of the Privacy Shield. And if you are in a position where you're a data controller outside of the EEA and you are dealing with processors that aren't able to be part of the Privacy Shield, maybe you are a data controller in India and you are using data processors in China, for example, then you're looking at the derogations, and obviously the safest one is that the data subject has explicitly consented to the proposed transfer after having been informed of the possible risks of such transfers, etc. So none of it is ideal, and I entirely share your frustrations. I know a few of you were voicing your frustrations in the group the other day, and I completely agree. And what we have to remember is that there is not, as I've said so many times, there isn't this vast worldwide data protection police force that is going to, be there on the 25th of May, making sure that all this is absolutely bottomed out. I think if you are working towards compliance and you're taking sensible safeguards with regard to this, particularly with the security of the data, and you've vetted your suppliers and they have the appropriate technical and organisational measures in place to protect that data, then you shouldn't necessarily lose sleep at night. But I completely agree. It's as did the lady at the ICO who I just talked to. It's a far from ideal situation, and to a great extent, of course, we're playing catch up. One of the options is that I didn't actually mention is standard. So in terms of the safeguards, so that we've got the safeguards and then you've got the derogations. Okay, so one of the safeguards is, examples of safeguards: binding corporate rules, standard contractual clauses, the approved code of conduct that doesn't exist yet, approved certification mechanism that doesn't exist yet. I mentioned all that before, but the one thing I didn't mention is standard data protection clauses adopted by a supervisory authority and approved by the Commission. And she also actually mentioned, she didn't mention the bit approved by the Commission, but she said she had some notes somewhere that said that you could have your own contract as approved by the ICO. But then she was saying, but we haven't got any guidance as to how that process would work. She said certainly if anyone, they haven't had one person apply for that, and they just wouldn't know what to do if somebody did. So, it's all it's very unsatisfactory, really. But there you go. So for those of you, this is an advanced video, okay? For those of you who have watched this far and you haven't been following the conversation about processes and international data transfers, I'm sure this will have gone way above your heads. But I just wanted to feed back my discussion with the ICO and also make that point that I did at the start about the fact that an international data transfer it's organisation to organisation and not data subject to organisation. I enjoy the conversation, but like I say, it's not. I don't really ever feel like you get to a satisfactory outcome. So the only comfort I can give you, as I say, is that even if you're not, doing everything exactly in accordance with what the GDPR says, you're probably going to be fine. Don't say I said that there. All right, I'll see you tomorrow.